turn it over to you.
Perfect. Thanks, Twyla. Hello, everyone. I'm glad that you were able to join us today. We're going to provide an overview of the New Mexico Indian Family Protection Act with an emphasis on active efforts and placement preferences. Our primary presenters are going to be Austin Moore, who's with the Native American Disability Law Center, Kip Bobroff, who is General Counsel for the Pueblo of Laguna, and Christy Chapman, who would, I'm going to allow her to introduce herself as since she'll be starting. The way our format is going to be changed a little bit today from the way we did it last Friday. What we'd like to do is we've emphasized in the slides sort of the key passages of IFPA to help sort of focus what we think might be helpful for you in your practice. What we'd like to do is spend maybe 15 minutes kind of going through the substantive issues of active efforts. As you have questions, please feel free to put them in the chat and we'll try and address it. But before we shift over to placement preferences, if we have 5 or 10 minutes before the half-hour mark, maybe we can spend a little time talking about just active efforts. Then we'll do the similar approach with placement preferences and hopefully have a little bit of time at the end for some more discussion and questions. Since obviously it's a newly passed statute, we're giving our thoughts on it, but we're going to try and stick as close to the text as we can, since that's what we have to go on for right now. And so we'll get started, but please, as I said, please feel free to put questions in the text in the chat, and we'll try and address them as they go along. Christy, would you like to get us started?
Sure, thank you, Therese. My name's Christy Chapman. I am from the Pueblo of Zuni. I am an attorney contracting with Pegasus Legal Services for Children, and also, full disclosure, I do also work for Native American Budget and Policy Institute. I currently am residing in Albuquerque on the lands of the Sandia people and the neighbors to the south is Sleda. And so with that, I'll begin just sharing from where we left off last time, always starting with who I am, where I'm from. Again, my background is what I know is shared with me through my great-grandparents and from them who they learned from as well. So again, my great-grandparents were Bawika, and always wanting to bring this in on any law. We also share our own indigenous law, our ways, our laws, our core values, grounding myself into the discussion up ahead. Next slide, please. When we're talking about ICWA and IFPA, we're always wanting to be mindful of keeping our kids in the heart of the circle. And just a picture of here, this is a woman with all her grandkids. When I say grandkids, it's her siblings, not just one sibling, but many of her siblings' kids. And they're all considered her grandkids or her kids. Next slide, please. And ultimately, in Indian families, there's always that sense of belonging, that relatedness, and that community. And just going forward, as we talk about IFPA and ICWA, but IFPA primarily, going into today's topics of active efforts and placement, always want to ground everyone in always putting kids at the heart of the circle. Next slide, please. Now, here I will pass it on, I believe, to Austin.
Thanks, Christine. Austin Moore, Senate. My name is Austin Moore. I'm a member of the Samish Indian Nation with ties to the Little Shell Chippewa tribe on my mother's side. As Therese mentioned, I'm an attorney with the Native American Disability Law Center. Thank you, everybody, for joining. So the first topic we're going to talk about is active efforts. And then on the screen here is the definition from the ICWA, and then the new definition on active efforts from the IFPA. Just a note that you guys correct me if I'm wrong, but the House bill has not been codified yet. However, this article that the IFPA will be placed into will be under the Children's Code in Article 28. So the section 4A, for example, in the IFPA, will be the same as it was in the House Bill 135, if you guys are trying to look at this before it's codified. So here you can see both of the definitions, and the main takeaway we wanted to share or point out is in the ICWA, the finding for active efforts is in the foster care placement or the TPR setting. However, the IFPA expands that into the any child custody proceeding. An active efforts is to maintain or reunite an Indian child with the Indian family. It's tailored to the facts and circumstances of each case, and then the department shall not seek findings of futility or aggravated circumstances. If you want to move to the next slide. So I think what's important to highlight here is that in the IFPA child custody proceeding, it means an action for foster care placement, termination of parental rights, permanent guardianship, or adoptive placement. But in the IFPA, it also includes investigations and other preliminary activities that precede the formal initiation of the action. So active efforts do start within the 24 hours of the investigation. But child custody proceedings do not include delinquency proceedings or custodial proceedings or kinship guardianship. Next slide. So this slide, definition from the ICWA and then the IFPA. This one's actually from the ICWA regulations, but the key point here is that active efforts are efforts that are affirmative, active, thoroughly, and timely, and that represent a higher standard of conduct than reasonable efforts. You can move to the next slide. So a really good resource I found for this is focused on the ICWA, not the IFPA, but the Native American Rights Fund, or NARF, has a practical guide to the Indian Child Welfare Act. And in that guide, they defined active efforts versus reasonable efforts, saying a rule of thumb is that active efforts is to engage the family, while reasonable efforts simply offers referrals to the family and leaves it to them to seek out assistance. And in the case law in New Mexico, in the Yodel B case, really highlights this difference in saying that the CYFD must do more than create a plan and leave it to the parents to develop his or her own resources to effectuate it. That's really what active efforts is, more than reasonable efforts. If I can read a quote from that case real quick, they're quoting the Alaska Supreme Court, but the New Mexico court held that passive efforts are when a plan is drawn up and the client must develop his or her resources, but active efforts is where state caseworkers take the client through the steps of the plan rather than requiring that the plan is performed on their own.
Right. I think here I would just like to jump in real quick and really to say why active efforts, as far as we know in ICWA, but we also know in IFPA that it's really not just about our children and our families, but it's really about tribal sovereignty and integrity. Showing integrity means not being passive about the efforts that are being made, but really engaging. And want to add to that, it's about preservation of our Native families and tribal sovereignty. I don't know if Kip wants to add anything to that.
So good afternoon. I'm Kip Bobroff. I'm an attorney, in-house attorney with the Pueblo of Laguna, and I represent the Pueblo in its ICWA proceedings. I want to make 2 points. One is we have already in the past 2 weeks experienced what can happen when the department gives immediate notification to the tribe when the investigation starts. And we were able to, because of that, resolve a case that likely would have brought the child into state custody. And because we were able to work together from the get-go, it didn't. So to me, that's one of the most important innovations of IFPA. And I realize that it may have not be immediate interest or use to the GALs, but it is really critical that the tribes and the state and the GAL are all collaborating. When it comes to active efforts, I want to just describe on a practical level how we have experienced it. We had a case not long ago where it was really critical that the mother get a psychiatric evaluation and access to medications which she had been on once before. She was having trouble getting a driver. She didn't have any identification. She'd been living on the streets, and she had trouble getting a driver's license. And for about 4 months, she couldn't get an ID, and so she couldn't get the services. And what the worker had done is, it was during COVID, but she had given her the sheet that explains how you get a driver's license. And it's well written, it's plain English. But if anybody has tried to help an indigent client get a driver's license, you know that it is not easy. And so for 4 months, this mother and the child and the case languished because active efforts would have required taking that client down to DMV and helping them navigate a very difficult process. So that's really, for me, a good example of the difference. And I'll turn it back. Or as they say lately, I yield back. Austin, we can't hear you.
Can I mute myself? You guys can hear me now?
Yes.
Okay, I'll be quick and then get back to you guys. So just real briefly too, active efforts. So the IFPA lays out some of the requirements by the department. So first, the document in writing that details the quality and quantity of service to alleviate the causes and conditions leading to the child custody proceeding must be on the court record. 2, the department shall assist the child's parents, guardian or custodian through the steps of the department case plan, and with accessing or developing the resources necessary to satisfy the plan. And then next slide. Oh, you guys are on it. So then 3rd, the department shall provide assistance in a manner consistent with the prevailing social and cultural standards and way of life of the Indian child's tribe. So I wanted to pass it back to you, to Christy and Kip. For you, what does it mean to provide assistance consistent with prevailing and social cultural standards?
I know this is where things can get also hung up on, well, what is that exactly? And here, really look into the tribe, because what you don't know, the tribe knows in terms of the social and cultural standards. Reaching out to the tribe and inquiring from the tribe. I know sometimes for some it might appear to be like resources, material things, but really a family is that social and cultural connection for a child. So whether it's a family member, a tribal member, looking to the tribe and getting their input on what that means is crucial, giving the tribe that discretion, that deference to determine what those standards are. So working with the tribe is crucial. As a GAL, to find out, to call your tribal equal worker, and go from there. When in doubt, call the tribal social worker. I'll pass on to Kip to add on.
So I would even, as a full-blooded non-Indian, I would even urge more strongly that the GALs do whatever you can to establish communication and a relationship with the tribal social workers. And I think they're a particular challenge to outsiders who are working with any community of which they're not a part. So, when Christy's working at Zuni, she's an insider in a way that, but just the fact that she went to law school, she is also an outsider. And less for someone who's part of that community, but a lot for the rest of us. We really have to come to this, I think, from a standpoint of humility and recognizing that what you don't know, and being open to learning and taking guidance from the people who do, which are the folks with the tribe. Now, it has to be recognized that the tribal social workers, the ICWA workers, are under tremendous pressure and very few resources. And so that creates challenges. But if you can establish that relationship, it can be of just tremendous benefit to your clients. I can't tell you the number of cases I've had in the 3 years I've been doing this for Laguna, where the state has had real difficulties engaging a parent. And when the tribal social worker has been able to make contact, they can have quickly been able to establish a relationship and engagement. And a lot of that is shared background, shared experiences, shared connections. It's not always possible, but in representing the interests of your clients, if you're able to establish that kind of a relationship in communication with the tribal social workers, you'll have much more success for your clients. The last thing that I'll say is, before I came out to Laguna, I was fairly Navajo-centric in my Indian law work. And one of the things that I have had to learn is that there's such a tremendous difference in terms of between Navajo, and my experience has been with the Pueblos in terms of information that I, as a non-Indian, as an outsider, am not supposed to know or have access to. And I have really gotten a lesson in being comfortable with not knowing and willing to cede to the folks from that community who do know. Christy, would you want to comment about anything further about what I was saying? Because
Yeah.
we talked about it more.
Yeah, I think just to talk about that piece where the state, of course, is an entity that for reasons does take children out of parents' homes. And to build that relationship really involves also looking at the historical trauma on the connection with parents. I know Kip stated that sometimes the parents don't want to talk to a CYFD worker. Why? Well, we look back historically. We look back at the stories that have been shared of how our Indian kids were taken. And so we hear from grandparents, we hear from our aunts that don't talk to them. Don't talk, you see a non-native person, don't talk to them. Why? Because the government did take our kids from us. And so sometimes there has to be a development of trust before an individual will be able to work with a worker. So making those active efforts really begins with trust. So with that, I'll move on to the next slide.
Okay, and then this slide is just a list of examples of active efforts that the IFPA does provide. I don't have to read all these individually, but as we're saying, establish services, include the child's tribe, consult with the child's extended family members, take steps to keep the child with their siblings. Yeah, we can go to the next slide. And then here, it's an 11-point list, but it's section 28.4C if you guys want to look at this list. The last thing I wanted to do was on the next slide. Oh, we still have a few more, sorry. So some more of the requirements of the department. Department shall record all efforts made and report them to the court. And then the court shall make a written determination at the conclusion of every proceeding. So again, not just at the TPR and foster care placement stages at removal, but written determination at every proceeding. I think Kip, you have your hand raised.
So I just wanted to make 2 points. One is there's an attorney on this call who I have worked closely with to monitor and to push the department to be able to establish and especially document active efforts, because without that kind of constant monitoring, it can really lead to just awful results. And so the role of the GAL in doing that is really, really critical. Not only to make sure that they're happening, but also to make sure that they are documented. And then the second thing is I put in the chat a copy of a decision, recent decision by the Washington State Supreme Court by a justice, the first native justice of the Washington Supreme Court, who is from Isleta and Laguna, Pueblo, and whose name flew out of my head. But I think it's the best opinion I've seen on active efforts and on ICWA in general, and I urge you to take a look at it. I was hoping somebody was going to jump in and save me, but you all didn't.
Estely put it in the chat, Justice Montoya Lewis.
Yes, thank you. Please don't tell her I forgot her name. I'm sure she's forgotten mine, so.
Okay, and then the last slide, before we can move into some questions and discussion. This is a non-exhaustive list, but these are just some of the places that the IFPA does note active efforts are required. So preventing the breakup of the Indian family, identifying whether the child is an Indian child, identifying family and fictive kin, complying with notice provisions, with placement preferences, and then to collaborate with the tribe to identify a QEW.
So there haven't been any questions in the chat regarding active efforts. I don't know if anybody, if you raise your hand, if anybody has a comment or a question. We're right at 12:28. Yeah, Marianne, please.
I'm sorry, I'm just going to talk because it's hard for me to do all that technical stuff. I just have a question about, hi, Dr. Bobroff. So I had a case that, well, it went up on appeal, it was discussed, but I made an argument that the court was breaking up the Indian family because the child was with the aunt and the nephew wouldn't take the classes. But anyway, to what extent are we talking Indian family? What now does ICWA include as the Indian family? If you could detail that for me, I'd appreciate it. In terms of siblings, parents, aunts, uncles, because I think that's important in any, especially with any kind of appeal on a case. Does that make sense, or?
It does make sense. Marianne, I'm going to ask if we can come back to that. And we'll give you an answer in a moment. I just want to check something. Unless somebody else is confident offhand.
I think in the prior slides from last week, I think it was last week, we did have those slides about not active, extended family, fictive kin, all that. But yeah, we will definitely answer that question.
Twyla just put it in the chat too. Thank you, Twyla. It's grandparents, aunts, uncles, brothers, sisters, brother-in-law, sister-in-law, niece, nephew, first or second cousin, step-parent, or godparent. As I recall, IFPA expands ICWA's definition by adding the godparent, but I think one of the most important provisions is that it is also, that's how it's defined in the statute after deference to the way the child's tribe defines family under law or custom.
Okay, well, thank you for that. I can just tell you that I lost an appeal because they did not consider the aunt as breakup of the Indian family. And it was quite a while ago, so I can't remember the details. So I would just suggest that that really be hammered in any appeal cases, because it was discussed. And I think there was a dissenting opinion on my behalf, but on the case's behalf. But anyway, well, I appreciate that. Thank you.
Thank you. If no one else has any comments, we'll move on to the placement preferences. But as I said, please make any comments or questions in the chat and we'll monitor as we go, and hopefully we'll have some time at the end as well.
Okay, thanks, Therese. So moving to placement preferences, we talked about this a little bit last week in the overview, so I don't have to go into it super in detail again. But as the IFPA defines placement preferences, first start with a list of least restrictive settings, closely approximates the family, allows the Indian child's special needs to be met, reasonable geographic proximity to the child's home, and then is in accordance with the order of preference established by the tribe by any means. And if the tribe has not established placement preferences, then that is when the IFPA's order applies in the next slide. So then here's the difference between the placement preferences for ICWA and then the placement preferences for IFPA. So first, the first two are the same, the extended family members of the Indian child, and then a foster home licensed, approved, or specified by the Indian child's tribe, which we'll talk about in a second. But then the way the IFPA changes from the ICWA is that bullet point 3, a foster home licensed or approved by a licensing authority in the state in which one or more of the foster parents is Indian. That's how the ICWA regulations have defined bullet point 3 for the ICWA. So that's sort of the same, but what the IFPA does is gets rid of the of institutions for children as a preferred placement in the ICWA. And then this graph looks a little bit confusing, but it's supposed to be under the IFPA. Under no circumstances shall an Indian child under 3 months of age be placed outside of the placement preferences provided in this section. So now what I'd like to go back to is that bullet point 2. If we wanted to have a discussion on what it means to be approved by the child's tribe. I don't know if we wanted to do that here or move on.
So I want to, is this where we want to talk about out of placement preference meetings? Okay, nobody, or is that below?
So, so the IFPA also requires that if a child's in and out of preferential placement, that every 30 days there's a meeting to determine whether or not placements comport with the placement preference. The department's already started doing these, so some of you may have already been in some of these meetings. And Christy and I, both as guardians ad litem and youth attorneys, have been in these meetings. One of the things we were talking about in getting ready for this this discussion was how this number 2 IFPA, the approved piece, interacts with that out of preferential placement, and how that might influence each other. I don't know, Kip, if you want to, or Christy, if you want to go further, and I'll be quiet.
So how the placement preference and number 2 might. So if an Indian child is placed in foster care placement that is contrary to the placement preferences, a secondary permanency plan shall not be simultaneously permitted. Mind you, this is new, and we haven't encountered this, but just in our discussions on going forward, we wanted to make sure that we are mindful of, well, if a tribe approves a non-ICWA home for placement, does this eliminate the need for what the department calls OPS or OOPS meetings, because they would have satisfied approval from the tribe of a placement. And with that, we would argue that the goal of IFPA is reunification with parents, family, extended family. So it would not necessarily end the what's now in law is the monitoring every 30 days when a child is not placed in a preferred placement. So I think we're going to have more discussions on this, but with us preparing for this, this is one of the things that we saw and just wanted to share with you all. And Kip, if you want to also chime in this regard.
So from a practical standpoint of the Pueblo's experience with, I like to call them OOPS meetings, but the out of placement preference meetings, those have been extremely effective and useful for the Indian children who are not in preferred placements, because it is a monthly opportunity for all the attorneys and the social workers and everybody to come together and talk about that case and what is being done to get that child into a preferred placement. And it really changes the dynamic. And so they're really critical. They've been really useful. But could you go back one slide, Therese? This number 2, I think it needs to be understood that just because the tribe does not object to an out of placement preference doesn't mean that they have approved it or specified it. And as Therese pointed out, when in much of the discussions, it was seen as assumed that those would be talking about placements within with Indian resource parents. But in fact, there are instances where the tribe will not object, but that's different from specifying or approving. And the reasons that's important is because the way it interacts between ICWA and IFPA. And if the tribe has not specifically, and I would argue in writing, approved the placement, then that OPP meeting has to happen every month. And it gives the opportunity for the GAL and the tribe and the attorneys, respondents attorneys, for everyone to really advocate, okay, what's being done to try to get this child into a preferred placement. And much of what we have experienced, and since I've been here, I've seen a shift, is that there are often efforts stop once a child is in what folks consider a good placement, regardless of whether that is compliant with the preferences. So I hope that provides a little more context. I know that Judge Terzinski asked what the rationale for the under 3 months of age placement was. And Therese, do you want to comment on that?
I'd like to hold off on that because I think we would be hypothesizing. I don't know if there's anything in the legislative record that explains that. I don't know, Kip, you were part of the drafting process, if there was a discussion that you can recall, but I would just be hypothesizing as to the rationale.
There's certainly nothing in the record, and I don't recall a fierce conversation. But I do know it's been our recent experience that the importance of being able to place children at that age, relatives in particular, is just critical because of all the evidence as far as bonding. And so that's, I'm sure, part of it. And I think it also is intended to really focus the efforts of the department to make sure that they get really young children placed with extended family or community members.
With that, I would just like to add, a child 0 to 3 months, as Kip mentioned, there's a lot of ceremony involved as well. And if the department's not making those active efforts to find and locate family, which in our Indian communities, it's pretty extensive. I did have a case where a child was placed in a non-ICWA home when there was family and the child was a newborn. But once that family was brought into the picture, the child was immediately returned to the family. And so it's really crucial in that regard that there are ceremonies that take place for a child when they're born. And so just want to also keep that in mind. Again, I don't know if there's any drafters who were a part of it from an MTIC on the line, but it would be, as Therese stated, to hold off on elaborating any further, but that would just be from a GAL perspective, the significance of placing a child with family.
We have another question from Sherry. She says, I represent a mom in an ICWA-IFPA case where the 2 girls are in a Navajo foster home and has not been the subject of a OOPS meeting or OOPS staffing. What should I do to correct this? Sherry, if the girls are also Navajo, then it would be, I think it would be a preferential placement, and that's probably why you're not having an out of preferential placement staffing. That would be my hypothesis. I don't know, Christy or Kip, if you have a different view on what should be happening in that case.
Yeah, the question that I always would raise is, are we continuing to look for family? What families are available? Who have you contacted? Because, the heart of it is family first, always. And, you never know out there if Aunt Mary's out there and we haven't contacted her. She's ready, willing, and available. And that, again, keeping it within family is crucial.
And Esteli, thank you for your comment. I think that you're right in that comment as well. So I think we'll move on. We're at about 1:45. So I don't know,
Okay.
Austin, if you want to pick this up.
Yeah, I can get through some of these. So then this is again just a list of examples where active placements must be met in placement preference context. This is in section 21C if you want to look at those. We can go to the next slide. Some more of the requirements. If the Indian child is in a foster care placement that is not a preferred placement, the court shall also hold hearings no less than every 6 months. And the department shall bear the burden of establishing good cause. And another point here, if there's a voluntary placement agreement in which the Indian child at first was not determined to be an Indian child and was later determined to be an Indian child, the agreement is voided. Again, this is why it's important for active efforts to start very early to make sure that these findings are made at the inception of the proceeding. So next we're going to move to adoptive placements. So these are in the Children's Code already. Yep, go ahead, Kip.
Before we move, just one other comment about foster care placements, which is to remember that under both ICWA and IFPA, the tribe has the authority to conduct licensing itself and approve foster care under its own procedures, its own criteria. If the tribe wants to receive Title IV-E funds, they have to include all the background requirements and so forth. But there are many times that I've seen where the tribe is able to move quickly and can license and approve of a foster care family that the state is running up against some problems with. And so I think it's important to always keep that in mind as a possibility and a subject of conversation with the tribe. And that also places pressure on the department to continue its efforts to try to develop more foster resources among tribal members and Native folks, Native parents.
I think that's a really good point, Kip. I've had cases where the department has not been able to find an appropriate family placement, but the tribe has and has expedited the licensing process so that the children can be placed appropriately. And so that is a valuable just practice point.
Okay, so then these are the preferences for adoptive placement. So these are the same as the ICWA. These are already in the Children's Code in Article 5. So then a piece here is the cultural compact. So if a child is placed for adoption or guardianship, that's not with a parent who's a member of the child's tribe, the court requires that the parties enter into a cultural compact, which is documenting on how the child will continue to actively participate in the child's cultural learning and activities and engagement with family members. Christy or Kip, I don't know if you had any comments on the cultural compacts.
I was gonna have Chip go first and then I can chime in after.
So all I was gonna say is we tried, but we're not successful in figuring out some way to have some monitoring or enforcement of cultural compacts. This is really an innovation that has come out of Julie Bird at the who's the ICWA liaison for the Pueblo of Nambe, and they have developed and used these, and I'm sure that they would be willing to share them. But I think the fact that we haven't been able to include any way to monitor and force any sort of compliance just emphasizes the need to use the process of developing them as a way of developing relationships. And I know, Christy, you have a lot more experience with peacemaking and other things, so if you'd like to comment.
Yeah, I love this piece. Prior to a cultural compact here, we were able to use what we call in the Western term peacemaking, but each tribe has unique ways of coming together and outside the adversarial process, coming together, hearing one another, and again, talking things out for the best interest of the child and really keeping the child at the heart of the circle, because the way we want to see things for our children is that they're not the ones being adopted. I really want to view this as families being adopted to the overall child's larger family. I think that's the best way to see how these cultural compacts will continue to keep a child at the heart while maintaining their ties and roots to their culture, when a household member is not available to take care of them, and when somebody else, non-native, is willing to step in and take that role. But agreeing by coming together and using those alternatives. So just wanted to add that piece as well.
And one of the things that I have learned since working for Laguna for 3 years is that I get a little impatient when we have OOPS meetings or other meetings. And actually, this has happened less in New Mexico and more in other states, where the child's with an out of compliance or an out of placement preference placement. And somebody will say, well, can the Pueblo connect us with some videos or books or resources? And I really lose patience, because that's not really the way that culture gets transferred and the connections get made. Those get made person to person, face to face. It's why placement with family members, with extended family members, members of the community is so important, is because the way a child learns the culture is every day, day in, day out, with people who are part of that culture. And that's not always possible, but the cultural compact gives a way, if it is treated seriously and as a part of the relationship building process, of trying to address that and create some alternative pathways for building those kinds of relationships. Because the most important piece is making sure that those children are able to spend time with the people who can teach them about their culture, because you're never going to get that from books or video or online language classes or anything like that. It's just it just doesn't really happen. So the efforts really need to go into how can you establish pathways for those relationships. The other thing I would say is that at least in Laguna, my experience has been, and this is confirmed with Laguna's social workers, Tracy Chapman and I'm sorry, I said Tracy Chapman, Tracy Zamora, and her team at Laguna Social Services, is that it's so much more common within the Pueblo for children to spend time being raised by extended family members. And that's not considered abnormal or unusual. It's part of the society. And so creating pathways for that to continue, even if a child is being adopted out or placed for guardianship with a non-member family, it's really important. So I'll get off my soapbox now about that.
Okay. I think you're gonna put "Give Me One Reason" by Tracy Chapman in my head for the rest of the day. But moving to this next one, again, one of the requirements whenever there's a change in placement, the department shall notify the Indian Child's Tribe by certified mail. Again, the tribes and pueblos can establish a different order of preference. So the order of preference established by the tribe and pueblo comes first, then the IFPA placement preferences. And then a piece here, I know that Christy's highlighted, is that when appropriate, the preference of the Indian child or parent may be considered as well. And that the child plays an important role with deciding who they want to live with. And then the last two slides I think we have, before we can open up for questions, are under good cause. So this is a list of, the way that IFPA does it, this is a list of items that cannot be considered as good cause to depart from placement preferences. This is in section 21H. And then the last slide has some more on good cause, so that the party asserting that good cause exists shall state the reasons for the assertion in writing. That party also has the burden of proving by clear and convincing evidence that there's good cause. And then the court's determination of good cause shall be made in writing as well.
Kip or Christy, did you have anything that you wanted to add regarding good cause, or what does and does not meet the requirements of good cause?
I think on the, which slide are you on?
We're on the last one.
The very, very last one?
Yeah.
Yeah, I think, good cause, in talking generally, sometimes good cause for resources not available for a child who is very medically fragile is a good cause to deviate, but that doesn't mean that active efforts end. I think what we've seen, what I've seen, and I think it's one word Kip also has experience with, is good cause temporarily in emergency short term is a reason to deviate for a child with a medical fragile state. One, because at times resources are just not available at the tribe, but once those resources are set up, once families trained, once families are assured and guaranteed that they are capable and educated on how to take care of a medically fragile child, then it's important to always make those active efforts to engage the family for placement, to be back with either family, extended family, or members of the tribe, or one that the tribe approves of. I don't know if Kip, you want to add on to that?
So I would add two things. The first is that maybe one of the few good things about the pandemic is that every court in the country, and I include tribal courts in this, I bet, have now figured out how to do remote appearances. And so now the what has periodically been tried as proof of good cause in terms of placements is often, I just realized I'm confusing good cause for placement preferences with good cause for transfer, and none of my colleagues saved me. So I apologize for that. I'll leave that. But what I was going to say, because I think it's relevant is Brian's question in the chat, is, okay, so what if they don't follow this? And I think that's not clear. In the last 6 months or so, the Pueblo of Laguna won a petition for habeas corpus because ICWA was not being followed. And the judge ruled in our favor. and returned the child to the custody of the parent. But I think it's a difficult question. It is clear that the appropriate parties have the right to any court of competent jurisdiction to ask for it. It's just not so clear exactly how that happens.
And I think Austin just wanted to point out the answer to that is in section 20, a similar provision in 1914. Is that correct? The correct
Right,
site?
yeah. So that section 1914, the IFPA includes pretty much the same exact section in section 20.
And we are right at 1 o'clock. I don't know if anybody has any additional comments or questions that you'd like to raise. Again, we're just trying to be respectful of the time that you've all set aside, and want to thank you so much for your interest in this. We have another session planned for next Thursday, also at noon, where we're going to focus on both working with tribes and Pueblos and the qualified expert witness. We also have, and we will be, as Twyla mentioned, we will be sending out the presentation, which includes our email addresses. Please, if anybody has any questions specifically that they'd like us to address or any comments on how we can make these better, please feel free to email me. We'd be happy to make any adjustments that we can. I know that we're all terribly busy, and we want to make sure that we're being really respectful of your time. So I really appreciate everybody taking the time today. I hope it was helpful. And as Twyla mentioned, I think we'll be having additional discussions and trainings as we move forward with implementing the statute that goes into effect next Friday. So hopefully over the months, we'll have additional opportunities to talk through some of the outstanding issues that we're facing. I hope everybody has a great afternoon. Thanks so much.
Thank you.
Thank you.
Thank you guys very much for the presentation. I really appreciate it. And thank you to all the attendees. And I will be sending out information. Anything I receive, I try to forward it to the contractor listserv or the NMFAP listserv. If you're not on that, feel free to email me, and I can either add you to the group you're appropriate to, or just make a note and start adding you to the stuff I send out gladly. And I'm going to stop recording if I can find the right button.